Hello, everybody. Welcome to the stream. I made it just on time. I was I was running late today, so up until a second ago, I was in the kitchen waiting for the kettle to boil because we cannot start this without having a coffee in our hands, can we? And as you can probably see, I'm upgrading the installation. So you see now we've got like blinking lights in the background and kind of various things that change color. Because I thought, why not? The place looks like a construction site, but we might as well kind of give it a bit of an effort into kind of spicing things up. But I promise you that as we are developing in our relationship together and as our developing our community and the people who turn up for this show, it's going to remain in this kind of artisanal style, but with more blinking lights. That's the plan. How is everybody today? It is a very grim day in London, unfortunately, because it's always on the verge of starting to rain, which is a little bit peculiar. So if you are in a nicer, sunnier part of the world, do let me know. Put it down in the chat so I know where you guys are connecting from. But yes, the situation for most of us here in the southeast of England is fairly grim, even though I am told that it's going to get better as we're moving into the weekend. All right, so how is everybody? We're here to talk about SQE prep and preparing for perhaps the July exam for those of you who are already registered to this, or looking forward to the next SQE1 exam that is coming up in January 26. So whichever one you guys are preparing for, I think this is a good opportunity to participate in the stream. We're going to have a bit of a chat about certain things that are interesting. Then we can go through some multiple choice questions. Then we can sort of all get together and have a good cry about how unpleasant this whole process is and try and build up a sense of community as we're going forward. So we've got a couple of people watching. So thank you very much for joining us live. For those of you who are joining us in the recording of the live stream, again, there are lots of things to see as we are moving on. Now, there's something specific that I wanted to talk to you guys about today. We haven't touched upon this year yet. I had a live stream last year when I was talking about this, and every time we're coming closer to one of the presentations of the SQE, I think it's a good idea to have a bit of a catch-up about this. What I wanted to talk about is how you feel up here in preparing for your exam. The mental elements that have to do with exam preparation are as significant as the actual, kind of learning stuff and getting on top of the substantive content and all the rest of it. And I have a feeling that we don't talk about this often enough. And I think this can become quite a stressful exercise for people. So I think it is a good idea to spend some time today talking about exam stress and what do we do with it, how it affects our preparation, how it affects our performance, and what are the best ways of recognizing it and then trying to work around it. Now, first of all, I have to say to everybody watching here that it is normal to feel stressed about an exam. Look, I've got my kids are kind of sitting GCSEs and kind of final year and A-level style exams and that at the moment. So it is normal to be stressed about it. Every time you're coming to an evaluation that's got a deadline, that's got a specific outcome that you want to build your future around, it is understandable and it's completely normal to feel stress. Never mind the expense, right? Because it's not just you signed up for an exam or you've got like a normal exam at uni coming up. You've got the very significant issue that you spend a great deal of money registering for these exams. Thank you very much, SRA. So it's normal that you get stressed. How do you experience that stress? What tends to happen? Well, it could be that you have physical symptoms when you're getting stressed up in preparation for an exam. It could be that you got headaches, you get stomach cramps, you just feel tense, you're irritable, you've got mood swings. I know that we can manage the irritable and the mood swings without an exam coming up, but perhaps the exam coming up makes it more difficult. The effect of all of this, that the physical aspects of feeling like a little bit unwell when you're overwhelmed with stress, actually can affect your preparation, because it makes it more difficult to concentrate, it makes it more difficult to retain information, it can affect the way your memory works, and then you get into this cycle of getting stressed and trying to work harder, but you're not very effective in your work, which makes you more stressed, which then makes your work even harder. So it's just this endless loop of stress that kind of fits into undermining your preparation. And I think it's also important to recognize, for those of us that live into households with other people, yes, it happens, the stress and the anxiety of it all is not just a problem for you. It can become a problem for the entire family. It can become a problem for your partner. It can become a problem for your kids. It can become a problem for your parents. It can become a problem for your roommates. It can become a problem for absolutely everybody. So step number one, when preparing for a difficult and challenging exam such as this one, is to acknowledge that exam stress exists, that acknowledge that it can have impacts on your performance, that it can lead to poor concentration, that it can lead to confusion. For instance, you can get mixed up between different aspects of the FLK and all of that stuff, which is, it's not great. And then it can actually cause other things that you have to deal with. For instance, you could experience great bouts of procrastination. Anybody heard about procrastination? Yeah, trust me. I'm an expert in procrastinating. I will spend time and do anything other than the things that I find stressful. So you can procrastinate and actually not progress with your work. You can have disturbed sleep. You can stop eating, or you could eat all the chocolate in the house, or you could fall back into bad habits, which is to smoke too much or to drink too much, or things like that, to take your mind off it. So be mindful that this will happen to you, and it will happen to everybody who's preparing for the SQE and everybody who's preparing for a big, stressful, expensive exam. Be there to acknowledge it when it happens, and be prepared to address it by taking certain steps. So, what are the steps that you can take to cope if you're getting overwhelmingly stressed by the looming SQE? Well, first of all, talk to people about it. Yeah, don't pretend that you're fine and everything's chill. I mean, not everything has to be like a sort of Instagram version of life where we pretend that everything is awesome. You are fine, and you are entitled to acknowledge that you're having this difficulty. And actually, you're going to find that people react to this positively. And even when, say, you've behaved in a way that's a little bit inappropriate towards the people around you because you're just so stressed and your mind is someplace else, then you can turn around and tell them you're sorry about it and explain what's going on. And you don't be afraid to do this, because you will find that people normally react very positively to something like this. So people will gather around you and attempt to support you in this difficulty that you're going through. And if you don't have an actual community of people around you, so you don't live in a house with other people, or you're not in a prep school with other students, or you don't have friends that are going through a similar experience, utilize whatever support communities you can find online. For instance, this is an opportunity here for an online community where various people who are preparing for the SQE are coming together. We've got our Facebook group in its two versions. One is the public version that's got a lot of people on it that are going through the same experience. Then we've got, for my channel members, a specific Facebook group. So make sure that if you're a paying member of the channel, then go to the special Facebook group that we've got. I'm going to put the link down in the description. And that's like a smaller community of people when we interact a bit more intimately. So, also, we've got, the people who participate in the live stream, apart from that, the people who subscribe to the newsletter, we've got a community there. So if you are not lucky enough to have people physically in proximity, or people that you can call on the phone and talk about your experience, utilize the various online communities that we have to to demonstrate that you're not on your own. And especially when you're finding things that are becoming stressful and it's beginning to affect your performance and to affect your behavior, joining up with other people who are having a similar experience can be very important. Now, what are we going to do in order to prepare effectively, especially for those of you, as I said, that are thinking about the July version of the SQE that's coming up in about just a month? Don't stress out. So we've got the big sitting of SQE1 for the summer coming up now in July. Now, what are we going to do to best prepare for this? It's always a good idea to have a plan of study. Now, depending on how advanced you are in your preparation, you could benefit for something like my study planner, for instance, that I produce a PDF study planner that's got specific starting points in the year. I do one from the end of the summer that takes us to the January exam. I do one towards the middle of the winter that prepares us for the July exam. So this is like a PDF planner that says what you should be doing every week to navigate effectively all the areas of the FLK to make sure that you don't miss anything out. So you can utilize my study planner, or you can utilize one that you make yourselves or others that people make available to have an anticipation of the content that you need to cover and make sure that you've got enough time available to cover that content. So if you have a plan ahead of you that kind of spreads the FLK on the period of time that you have available for this exam, you're going to find that you stress less, both because you see more clearly what it is that you have to do, and because you can also achieve certain milestones that you set yourself in putting this plan together, so you verify a sense of progress. Because one of the things that are stressing people out in this exam is not only the inability to project the entirety of the FLK against the time that you've got available, and people keep thinking, I've got so many things to do, how am I going to get this done, right? So if you have apportioned time in a way that allows you to cover the totality of the FLK from the point that you're starting till the point that you've set up for your exam, then that anxiety goes away. And then if you have a set of milestones, you know that you have achieved those and you feel better. So you no longer have to stress about this vague, enormous syllabus that you need to go through, because by achieving those milestones, you demonstrate your progression through it. And what I've done in the study plan is not only spread the FLK against a period of time, but also to give periods for rest, reflection. So you actually get to kind of congratulate yourself that you've covered some bits of the FLK that were necessary. You can take a week off, or you can take like a few days to sort of quickly revise, and then you progress into something else. So it's important to have a clear view of the time ahead of you, to apportion the syllabus against that time, and also to take the time to actually celebrate the fact that you meet certain milestones and that you're making progress. So this is something that, to a degree, if you go to prep school, it will be provided to you by the prep school. If you're self-studying, however, it's something that you need to make for yourselves, either by utilizing the tools that I mentioned, or by just having a good look at the calendar against the breakdown of the FLK and making sure that you have certain deadlines that you're going to try and meet. I mean, missing a deadline is not the end of the world, but having a clear pathway towards the end of the syllabus, I think, is going to make a very big difference, and is going to be positive for everybody. Now, when you actually get down to study, right? Now, how do you manage this without falling asleep? That admittedly is a bit of a challenge, because there are certain parts of the FLK that you might kind of engage with and you find them interesting, or it could be parts that you know better because you work in these domains, or you've studied them more actively at university, or you took modules on them or something. Great. But there are going to be parts of the FLK that are really dead boring and very, very difficult to navigate. Now, people tell me that they're struggling with the property stuff, the conveyancing stuff. this stuff can be very, very dry, and you might have to struggle through it. Now, how do you manage to keep yourself awake and motivated when you're dealing with aspects of the syllabus that you find either difficult to understand or extremely boring? Now, one technique that we've come across, and if you try and Google this stuff or you ask the chatbots, you're gonna get recommendations along those lines. One of the common techniques that's getting recommended is the so-called Pomodoro technique. You know what? You've heard of this before? Pomodoro is like tomato in Italian, right? And it is called that because somebody had a tomato-shaped kitchen timer. Yeah. And they thought this is actually a great idea to use the chicken. I keep thinking chickens because I made a video. Did you guys see my video with the chickens? You gotta tell me. If you saw the video with the chickens and you liked it, leave me a comment down in the description. If you didn't see it and you're wondering what's this guy talking about, go to my latest published videos on the channel and you're gonna see I made an animation with chickens that I think is great. Right? Yeah. So not chicken, kitchen timer. Yeah. So the guy thought, okay, well, I'm going to take my tomato-shaped kitchen timer and set it to 25-minute intervals. So I get 25 minutes of work, then a forced break of 5 minutes, and then another 25 minutes of work. So the logic behind this is that breaking the study time into these kind of compressed time frames helps you to avoid procrastination because it gives you a goal, and also it allows you to maintain your energy and your motivation. Plus, it builds in certain break periods. So instead of just sitting there with a book, kind of falling half asleep and, the property law stuff hitting you in the head every time you nod off, you can use something like this, have a timer, have an alarm that ticks every like 20 minutes, 25 minutes. You know that you've completed your block of study. Take a 5-minute break, go out, have a walk in the garden, play with the cats, call a friend for a chit chat, and then you come back to it another 25 minutes on your timer, and that can help to actually force you to go back for the study. And it's probably a good idea to switch off YouTube. Not me when I'm on, you get to watch me, but try and avoid other distractions. Because if you've got, your social media feeds in the background, then there's always going to be something to attract your attention and you start doing something else. So if you can avoid other distractions and focus on the task that you're doing within these timed periods, it can help you to stay more concentrated and motivated. Now, it's possible that people use music to help them concentrate. Now, I'll tell you what, I've tried this. The ambient music stuff that you get kind of sea sounds or jungle sounds or birds singing and so on, I don't like that because that annoys me after a while. I mean, other people do it effectively. I mean, my daughter, for instance, she puts this kind of static noise in the background, and that actually helps her concentrate. Now, the logic here is that if you have an audio background, then the part of your mind that is bored and wants to run away is focusing on the audio background, and it releases the rest of your attention to what you're studying. I used to do that with music. So I used to play music I like in the background, something not too intrusive, but something that can be, you hear it play, but you cannot forget it in the background, right? And I used to do this. And I found that it was helping me when I was reading, but when it came to writing something, I needed quiet. Because if I had music when I was trying to write, I found that distracting. But, you can try it and let me know what works for you guys. Also, I mean, there's always attempts to gamify the experience and to give yourselves like within the task certain rewards or motivations or kind of alerts and stuff that makes it a little bit more interesting. Now, this is probably done from the point of the provider that is putting the material for you, as opposed to you doing it by yourselves. I guess you could try multiple choice questions, and every time you finish like a set, you can kind of go around the room and cheer. But I have thought about the ways that we could gamify the experience. For instance, I presented a few multiple choice questions in the format of a game show where two contestants are kind of, one is asking, the other one is answering, and so on. Anything to kind of liven things up a bit. So anything that you can find that encourages you, if there's a game built into your preparation, if there are flashcard challenges, if there are, like, you join an MCQ tournament. Shall we do this? We should do this. We should organize an MCQ tournament and see how many MCQs we can go through before passing out. Yes, so we can do this with the apps that are offering us endless streams of MCQs. We should actually hit that and keep on going and to see how many we can do. Actually, you know what, guys? We should do this for the next stream. We should actually launch the app and go through as many MCQs as possible and see how many we can get through in an hour or two. Yeah, would that be fun? Let me know in the chat if you think that the kind of an MCQ tournament would be something that we want to do. Right, I should make a note of this. This is a great idea. Okay, now, perhaps the next part in this preparation, we talked about acknowledging the stress that comes with the exam, getting to terms with the fact that, yes, this is going to be stressful, and yes, this is a challenging experience, and to learn to recognize it and to kind of attempt to live with it, I guess. We've talked about some study tips and how to manage our time and so on, which I think is going to be helpful for everybody, regardless of the point of preparation that you got. Right? If you're starting early or you're starting late, I think it's always good to have a sort of study plan to anticipate what's going to happen in the time that you've got available. But the next thing that I think we should talk about is taking care of yourself. So don't go hungry because you're sitting there answering multiple choice questions for like 5 hours in a row. Make sure that you're properly fed and that you take care of yourself, because your body needs to be there to carry your head while you're sitting through the exam. So if you're physically tired or you haven't eaten properly, then this is bound to affect your chemical balance, and it's bound to affect the way that you can concentrate and approach the exam. So make sure that you have had something to eat before you go into the exam. Being mindful of Kaplan's instructions, because you cannot take anything you want within the exam. So be very careful about this. And they keep changing their rules as well. And avoid, how shall we put this? Chemically induced solutions to your problems. So if you're stressed out and you cannot sleep and you take sleeping pills, maybe that's not going to leave you in the best condition the next morning. If you are feeling sleepy and you're trying to wake up, maybe having like 15 cups of coffee also is not going to be helpful, especially if the day after you're meant to go there and kind of start working on your exam. Try something that is a bit kind of less chemically induced. So try a mindfulness app. Have you guys tried this? I know I'm talking about not drinking too much coffee when I'm on the 5th coffee of the day, but I'm not the one sitting the exam, yes? So I can get myself overtly stimulated, and then I'm going to have the opportunity to calm down. Use mindfulness and relaxation tools. I mean, there are a variety of these. You can watch some YouTube videos about it, or you can have an app, or you can put some music in the background on Spotify or something that can help you in the times that you've set for relaxation and to take your mind off it. It can help you disconnect. Now, when it comes to the final weeks of your practice, and now we are at the final weeks of our practice. Yes. So any suffering souls in there that are going for the July exam, let me know in the chat. So you cramming for the exam is understandable, and that's what everybody's gonna try and do towards the date itself. Is you're gonna try and revise as hard as possible. Now, you have to be smart about the way that you get this information. Try practice MCQs as much as you can. I've got some recommendations for you coming up in a moment, but even just going through the newsletter questions that I'm sending every Monday and going through the back catalog of those questions is going to be helpful for your revision. And You can find MCQ titles, revision books. I mean, I always recommend the Revise SQE titles. They've got 2 nice revision books now packed with questions on FLK1 and FLK2. So try, by all means, the computerized exams for as much practice as possible. But if it would be helpful to kind of sit in the couch or kind of sit in the sun in a chair, if it ever becomes sunny, that is, maybe a physical book can also be helpful in kind of diversifying the medium through which you're receiving your question preparation. So think about this. Maybe a physical book in these last few days would be helpful in giving you like something other than staring at the screen all day long. So yeah, so that's it. So it's okay to cram. It's okay to up your engagement towards the end of your period of preparation for the exam, but you need to be smart about it. The idea is not to exhaust yourself, and it's okay to eat properly as you're preparing for the exam. You can have the extra chocolate. You're gonna need, the additional calories. You're gonna burn them through. Don't worry about it. Okay, right. So. Hopefully this is helpful for you guys. I see some people have joined in the live stream recently, so it's great to see everybody. Feel free to put a word in the chat to let me know how you're getting on. What we've been talking about so far is predominantly trying to stay sane and not to go crazy in the last few weeks before the exam, and primarily how to deal with the stress of it all, and especially in the build up to the exam, and what would be like an effective way what would be an effective way to actually prepare for what's coming. I want to reiterate, it is normal to be stressed when you're preparing for a big, expensive exam that's got consequences for your career. On the other hand, you need to keep a slight sense of perspective, right? As we know, it is possible to retake the exam if it doesn't go well. So we've got some backup. And remember that while being stressed to a certain degree can be helpful and it can be motivating and it can keep you on track, if you let yourself get stressed out of bounds, then it can undermine your preparation. So be very mindful of what's happening in your head and how you're feeling emotionally as you're getting closer to the exam. Okay, cool. We've got some people in the chat. One of our channel members as well, Fosa. Hi, thank you for joining us. Yes, and one of the people in the chat is saying they're preparing for January. I think giving yourselves as much time as possible is the best idea. It can be very stressful before you've had a full appreciation of the content that you need to cover to go and register for an exam. I know that some people work well if they've got a looming deadline. So some people, to get motivated, they need to have a specific deadline. Otherwise, they keep putting it off and they're thinking, okay, I'm going to sit the SQE next year or the year after, and they can never get themselves started because they think it's too far away. So I know that some people have booked for the exam as a way to get themselves working towards this exam. But you need to have a genuine assessment of your substantive knowledge background before you set off, and you also need to have a realistic assessment of how much time can you devote. Because somebody who has an English law degree that covers, like, say, 70% of what you need for the SQE will need some time to get back on speed with the substantive content, but it's going to be faster if they're not in full-time employment. And that is one of these things that we're having difficulty with, because when we're telling people we kind of think you need 6 months, what are we talking about? Is it 6 months if you're not at work and you're at home? Or is it 6 months if you're working part-time and you can only study a couple of hours per evening and over the weekends? Okay, wow. So one of the people in the chat is saying that they're preparing while they're actually doing the LLB. Man, that's ambitious. Yes. I mean, on the other hand, if you're a full-time student and you're not holding a job at the same time, then you probably got the time available to do the SQE prep on the side. And I have heard from other people as well that people are trying to do the SQE preparation at the time that they're actually finish off their law degree. So then they get their degree and then they can go straight on for the exam and then sort of accelerate the whole process. But this is so dependent on personal circumstances. It depends on what is your starting point. So how much about English law and all these processes you know about already. Do you know them, or do you need to start from scratch because you know nothing, or do you know them through practice? Perhaps because you're a foreign qualified lawyer, but you've been working in this jurisdiction for quite a while. So a good assessment, a good triage, if you want, of your level of knowledge in relation to the FLK is super important. And after you've done this and you've identified, this is what I know, this is what I don't know, this is what I need to kind of brush up on, then you need to think how this sits in relation to your personal life and circumstances. Are you at home? If you're at home, do you have enough time? Because it could be that you're at home because you're on maternity or paternity leave. It could be that you're at home because you're taking care of kids or elderly relatives, or it could be that you're at home because you're a carer, right? The fact that you're at home and you're not in full-time employment might not necessarily mean that you can devote all that time for SQE prep. So whether you're in employment or not is an issue. What other obligations in life do you have is an issue. And have a realistic assessment as to how long it's going to take you, judging from your starting point of knowledge, and then moving on to what your life is really like and how much time you can set aside for the prep. And I know that if the conclusion is you need more time and you won't be able to sit this quickly, it might be disappointing and you might find it frustrating because you might think, whoa, I wanted to get this done, to get started with these exams in 2026. But if I'm realistic, I'm going to have to start a year later. And this can be demotivating. But on the other hand, it's better to be careful than to rush into it and then stress yourself to death a couple of months before the exam because you realize you haven't made enough progress. So, for those of you who have joined us later, or if you watch on the live stream, go back to the stuff that we said at the beginning of the live stream, the first 20 minutes or so, when I was talking about how you're going to experience stress or how people experience stress and what could possibly be done about it, and then how careful planning of the time that you've got available against the requirements of the FLK is important to help you manage the whole process. Yes, so oh man, yeah. So hopefully you're not one of my students. So I won't take this personally. So the comment that we've got in the chat is that the LLB, which is the qualifying law degree, or at least it used to be the qualifying law degree, didn't cover any of the topics fully. So now our friend here says they have to study it for themselves. Yeah, I know. Tell me about it. Because not only we don't cover the totality of the FLK during the law degree, the bits of the FLK that we do cover, we cover them from a completely different perspective. So even though you've done, say, contract, tort, and potentially business law, if you took the right modules, you have probably covered the headline requirements that the SRA puts there. But the way in which we talked about it was different. Because at law school, we spent ages talking about the reasons why the law came to be the way it is, or processes of law reform, or critique about the law, what the law should be, and then thinking about the cases and what the judges are saying, and analyzing this and analyzing that. The SQE doesn't care about any of this, right? The SQE is just bang, 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 scenario-based problem questions. What would a real-life situation be? And that instant answers to that. So it's very strange that not only great parts of the FLK were never taught in an undergraduate law degree, they were the content of the LPC, but even the ones that are done, you shouldn't assume because you've done them at uni, you're fully prepared for them in the way that the SQE addresses them. Now, if you're doing a different type of law degree, if you're doing a combination like LLB with business, like a law with business degree or something else, it could be that you're missing entire components of what will be in the FLK syllabus. Now, if you guys are wondering what is this FLK, this is the functioning legal knowledge. This is the sort of background knowledge that one is assumed to have when they walk in their first day on the job trying to work as a solicitor. So this is effectively a little bit of everything. Okay, there are some stuff left out, like family law and so on, but there's effectively a little bit of everything from more areas of civil and criminal law, including the procedures that one would come across if they were a lawyer in the real job. Now I've got another kind of video when I'm ranting about how the sort of day one outcomes that they call them are really not achievable for somebody who's preparing to take an exam. It's mostly they're asking you to have the knowledge that you would have if you were already working there in order to be admitted into the profession, when clearly you couldn't have had that because you're just now sitting the exam. But anyway, we will deconstruct why the SRA has done this at a later point. But the important thing is this: even if you have a recent law degree from an English university, do not assume that they have taught you the FLK. All this functioning legal content, there are specific areas that the SRA requires that are examined that are not necessarily, and usually not part of a traditional law degree. And if you've done anything that kind of diverts from a traditional law degree, as things are beginning to shift lately, right, where people are doing kind of lots of other things and they're calling them law degrees, then it gets a lot worse because you could be missing a lot more. Now, for a better impression of what is in the FLK, I've got a couple of lists that I've put on my website that break down. They've got two big charts that I've got all the elements in the FLK. So I've got this is what the topic is, say dispute resolution or contract law or business law, and then I've got all the headlines that are getting examined. So all the things that you need, both all the main themes that you need to know, but then also all the topics that are within those themes. And not only I've got these two big tables to kind of quickly refer to if you're trying to familiarize yourselves with what's in the FLK, I've also linked them to specific videos where I talk about that stuff. So there's a video that covers, I've got videos that cover everything, the totality of FLK1 and FLK2. And if you are new to the area, or you've got very significant gaps in the area, because this is something that has not been taught at all when you were doing your degree, start with that list to make sure that you gain at least an initial perception of what all the topics are, and then click on the videos that offer you kind of podcasts and presentations about all these topics. So that way you can have a sort of broad introduction into what's going on, and after that you can do more concentrated study. You can kind of go, right, now I've got a vague understanding of what criminal trials are like, yeah, because I knew nothing about this before. So now I've got some idea of what criminal trials are like. So then I can now get deeper into some material. I can read some books, or I can watch more dedicated videos or podcasts that give me the additional information. So this is an entry point into that field, because I do find that I come across quite a lot of people who don't actually know what the syllabus is meant to cover. That's not a personal failure. That's a failure on the part of the SRA, that we still got a great number of people who kind of go, I did a law degree, I'm going to sit the SQE. The SQE is just going to be like everything that I did in years 1 to 3 put together in multiple choice tests. I should be fine. And people don't really appreciate the distance between the content that we cover in our law degree and what's actually happening in the FLK. So that's why if you're looking for a starting point, especially for those of you that are not with a prep school and you're preparing independently, if you want a starting point, then the video lists that I've got that break down the FLK might be an interesting place for you to start from. Okie dokie. Now, time for some tricks and tips. Let me try and share my screen here, and I've got something to show you guys. Let's see if that's gonna work. Aha. Is it on or is it on? It's trying. Come on. What is this black screen? Ooh, I think we should be up now. Yay! I don't know why it takes forever for the slide to change, but at least hopefully you can see it now. All right, cool. So we are here. Let me show you this. I told the people in the group, in our closed, in the members only Facebook group, that I was negotiating some deals. So now I'm ready to propose some new deals for you guys. So I've already negotiated a couple of discounts. So we had a nice discount code for Revise SQE that's coming out, in the codes are in the newsletter that I'm sending every Monday. So we've got a good discount code for Revise SQE that gives you 10% off all their products, including the bundles that they put together. We have other discount codes for online apps and support tools. And now we're adding to those a new one. So I don't know if you guys have come across this. This is one of these online offerings. It's one of the apps that creates banks of multiple choice questions. So I've been playing around with this platform and I tested it, and I think it's really nice. So it's worth having a look. And the people from the platform that is called Kinu, they've been really, really nice and generous, and they're offering 50% off the subscription for the first 3 months, and you get a 7-day trial anyway, right? So everybody gets the 7-day trial. So if you don't like it, you don't have to pay anything, and you can kind of knock yourself out doing MCQs while you got these 7 days. But if you like the product and you want to stay on, if you use the code that you see on the screen, that is Ioannis50, like this, because this is case sensitive, right? So all lowercase. If you use that, it's going to give you 50% off the first 3 months. So if you guys were looking for additional multiple choice questions, so you can practice as much as you can, then this is a new offering in the market that I thought it would be a good opportunity for everybody to try it out. By the way, let me know in the chat, how do you guys source multiple choice questions for SQE1 so far? Are you, because the options are what? Either you're with a prep school and you're getting access to their banks of questions, or you purchased a book like the Revise SQE books with the MCQs, or you are getting all the free samples that you can find from all over the web, or you are with one of the online apps that provide multiple choice questions, and some of them offer mock exams and stuff like that. So let me know how you're sourcing your questions, because clearly that's important. And I'm sure that some of the people who are watching this are in the receipt of my newsletter anyway. So just in case you didn't know, let's see if I can never talk and type at the same time. So this is my newsletter that's it, newsletter at glintis.co.uk. I'm sending fresh MCQs and study material and tips and discount codes for relevant stuff every Monday. So if you guys are not already members, email at this email address with subscribe as the subject matter, and I'm going to add you to the newsletter. And if you just go to the website, you can see all the previous ones, right? So they're not they're open to everybody. They're not locked or anything. So you can go through all the previous newsletters as much as your heart desires. Okay, shall we? Because we've talked about a bunch of interesting stuff today, but we still got some real work to do. Shall we go through some multiple choice questions together? What do you think? Yes? Give me like an enthusiastic emoji if somebody wants to do some MCQs. Nobody wants to do MCQs. You're all sick of them. Well, we're going to do some anyway. There's no hiding. There is no hiding from the MCQs, people. Right. Okay. So let's see if we manage to change the screen. Yes, we have changed. We've changed our screen. So let's see what we've got. Ella is the director of Fresh Farm Limited. This is a company specializing in organic produce. She's also the director and shareholder of another company, which is called Green Grocers Limited. It operates within the same industry. Fresh Farm is in the process of negotiating a lucrative contract to supply organic vegetables to a major supermarket chain. Ella attends a Fresh Farm board meeting where they discuss the contract terms of this new deal. Shortly afterwards, she approaches the supermarket on behalf of Green Grocers and secures the contract for her own company, undercutting a Fresh Farm Limited in the process. When the other directors of Fresh Farm find out, they accuse Ella of breaching her duties as a director. So, question for you. Which of the following duties under the Companies Act 2006 has Ella most likely breached? And what remedy might Fresh Farm likely pursue? So, is it 1, the duty to exercise reasonable care, skill, and diligence? So, Fresh Farm can sue Ella for negligence. Is it the duty to promote the success of the company? So, Fresh Farm can apply to the court for an injunction preventing Ella from acting as a director. Is it the duty to avoid conflicts of interest? Fresh Farm can seek an account of profits for the benefit Ella obtained from the contract. Is it 4, the duty to declare an interest in a proposed transaction? So Fresh Farm can rescind the contract Ella secured with the supermarket on behalf of Green Grocers. Or is it 5, the duty to act within powers? Fresh Farm can request that Ella be removed as a director under Section 168 of the Companies Act. Okay, so we've got Nadim suggests question 4, answer 4. Okay, 4 being the duty to declare an interest in a proposed transaction. Does everybody else agree with this? Shall we go with question 4? Actually, I would go with 3. Yeah, Lina there suggests 3. I think we need something broader than 4, because 4 is about an interest in a proposed transaction. She's done it already, right? So it's not only about the proposed transaction, it's actually worse. So number 3 is the duty to avoid conflicts of interest, and then Fresh Farm can seek an account of profits for the benefit that Ella obtained. Now, why should it be 3? Because we got Section 175 of the Companies Act. That one says that the directors are required to avoid situations where they have or could have a conflict of interest with the company. So Ella got the contract for Green Grocers. It's a direct competitor of Fresh Farm. Ella has placed herself in a direct conflict of interest because she's working for 2 people who are pursuing the same objective at the same time, but she cannot obviously satisfy both. This is something that we saw in last week in our other live stream as well. If somebody could be director in 2 places. That's not prohibited. But while there's no prohibition in being a director for multiple companies at the same time, if the companies are doing the same job, then if you're presented with an opportunity that would be good for one because they're in the same field, the same opportunity is going to be good for the other. So how do you make the choice? Every time you divert the lucrative opportunity to one or the other, you're satisfying your obligation to them, but you're breaching your duty to the other. So it's not possible that Ella here can effectively operate as a director both for Fresh Farms and for Green Grocers. So the board is right to complain. When she took this negotiation and made it her own and diverted it to her own company, then she breached her duty. So the other options are not particularly great as an answer. So option 1 is incorrect because the duty to exercise reasonable care, skill, and diligence is about the standards of competence, right? This isn't about her being competent or not competent. This is about her making choices when she was under a conflict of interest. Option 2 is about the duty to promote the success of the company. This is one of the general duties, but again, this is what the problem is here. It's not like she didn't care about what's good. She just chose between the two different people. 4 is incorrect because this is about declaring an interest in a forward-moving thing. This has happened already. And 5 is possible in the circumstances. It's something that they would practically do, but in fact, it doesn't really solve our problem because removing her as a director, they probably would because they're not happy with her, right? But removing her as a director doesn't solve the problem that they lost on this beneficial contract. So the most appropriate thing to do is to say there was a conflict. This conflict was not resolved. She went ahead and did something that has caused harm to the company. So the appropriate solution here to resolve that is to have her compensate the company for the money that the company has lost. Remember that if we're in a situation of conflict, it doesn't really matter whether the company suffers loss as a result. The fact that the director is in a position of conflict is a breach of their duty to begin with. But if, in addition to the breach of duty, what has happened has harmed the company, then the company has the right to request compensation from the director. So, in fact, we arrive at the conclusion that the appropriate answer here would be question 3, the duty to avoid the conflict of interest, and because the company has actually suffered harm, then Ella would need to account for the profits that she made out of diverting this opportunity. So, yes, if Ella had studied company law at school, or if she had prepared for the SQE, she would know better than to done this. So, she brought this upon herself. All right. Now, let's move on. Now we have Sophie. Sophie is an elderly woman. She owns a valuable piece of land. She's got a nephew, Tom. Tom's been helping her with day-to-day needs and managing her finances and so on. He suggests that Sophie should sell her land to him at a price way below market value. Now, Sophie, of course, doesn't necessarily like this, but Tom insists, saying that he might no longer be able to take care of her if she does not agree to the sale. So, under this pressure and fearing the loss of Tom's support, Sophie reluctantly signs the sale agreement. A few weeks later, Sophie realizes that she may have been pressured into selling her land at an undervalue and seeks legal advice on how to challenge the validity of the sale. Which of the following principles best applies to Sophie's situation, and what must she demonstrate to challenge the validity of the sales contract? Is it 1, the principle of undue influence? Sophie must demonstrate that Tom exerted improper pressure on her due to the relationship of trust and confidence that existed. Is it 2, the principle of duress? Sophie must show that Tom used illegitimate threats to coerce her into signing the contract. Is it 3, the principle of misrepresentation? Sophie must demonstrate that Tom made false statements about the value of the land to induce her agreement. Is it 4, the principle of unconscionable bargains? Sophie must prove that Tom took advantage of her vulnerability without providing adequate consideration. Or is it 5, the principle of mistake? Sophie must show that the contract was signed under mutual mistake and seek rescission. Okay, what do we think about that one? Which principle actually helps Sophie get out of this contract? So we have undue influence, duress, misrepresentation, unconscionable bargaining, and mistake. I know which one I would choose. Let's see. I am going to vote. We've got a vote there. Yes, I am going to vote for number 1. Yep, agree with you guys. It is the principle of undue influence. What is happening here is that this is a relationship of trust and confidence. And one of the parties is taking advantage of that trust and confidence to guide the other party to do something. So the reason why this is a problem is that Sophie now, who's the subject of this compulsion, is not really making independent choices. And in the field of undue influence, you've got 2 types of situations. One is actual and one is presumed undue influence. Actual undue influence is where you can produce evidence that, in fact, you had a close relationship of trust and confidence with the person and they took advantage of it. Presumed undue influence is the situation where, out of circumstances, the law assumes that you are under not the control, but you're under the influence of somebody. So if somebody is your teacher, if somebody is your priest, somebody is your doctor, that sort of stuff creates kind of power dynamics. And usually people defer to others if they've got this official position of authority, and they tend to follow their advice, even when it attaches to kind of personal issues or something else. Now, here we might not be in the area of presumed undue influence because Tom is a family member, but not necessarily in the kind of hierarchical position that the law assumes. But I think we've got enough evidence for a finding of actual undue influence. What's happening is that Tom really has somebody who trusts them and relies on them and takes advantage of that trust and reliance to achieve a personal benefit. Now, what would the consequence be? The consequence of a finding of undue influence is that every contractual relationship that arose as a result is voidable. So if Sophie complains, then she can void the transaction, so she does not have to sell him the land. Now, the other answers are close, but not quite there. You will remember that the way multiple choice questions are set up for the SQE, they normally give you a complex scenario and a set of questions that are related, but out of them, one is more correct or more appropriate than the others. So it's not like out of the 5 possible answers, 4 are complete nonsense and only 1 seems to relate to what's going on. Most of them, most of the time, will be plausible as answers. But your job is to find the one that is a little bit better than all the rest. So as we've said in previous streams, do not try and find the one correct answer amongst a multitude of completely wrong ones. Try to find the answer that is a little bit more correct than the others. So try to find the one that matches a little bit better than the rest. So undue influence here matches well. Duress does not, because duress involves a threat. If you will remember the definition, duress is an illegitimate threat that coerces consent. Illegitimate threat means that somebody is threatening to do something they're not allowed to do by law. Yeah, but we still need the threat. So could we argue that Tom saying that he might no longer be able to take care of her sounds as a threat, and then she entered into the contract as a result? It's possible, but not likely. In any event, this would be a more difficult outcome or a more difficult argument to present at court than the one based on undue influence. So I'm not saying that an argument on duress here would be 100% wrong. I'm just saying that it's not as right as the argument on undue influence. Misrepresentation doesn't work. Misrepresentation relies on a false statement of existing fact that induces the other person to enter into the contract. Tom is not the one. Tom is the buyer here. It doesn't really seem to match the facts of what's going on. Again, I can see why somebody might think around those terms, but if you break it down and you try to find the false statement of fact, there isn't really one, because that needs to relate to the actual transaction, not about things that are around it. The principle of unconscionable bargaining, again, doesn't help us here. Because the problem wasn't whether you got enough of the fundamental elements of the contract or there's some fundamental injustice. It's more the context in which Sophie is pushed to make that decision. And mistake doesn't arrive here because there is no mistake. They're not mistaken as to what they're doing. They know what they're doing. The problem is their motivations for deciding to do it. So there we go. I mean, the most appropriate, the closest match with what's happening here is the one with undue influence. So, and remember, if you got any family members that come and ask you for money, this is always going to be trouble. Be wary of transactions with family members. All right, let's see what happens after. Okay, now we've got Mason coming up. So Mason owns a small construction company that the company has been hired to renovate a block of flats. While working on the project, one of Mason's employees, Jack, accidentally leaves a piece of heavy equipment on the edge of the scaffolding. The equipment falls, hits a pedestrian on the head. So that was Clara as he was walking below. It caused her serious injuries. Clara wants to sue Mason for compensation, arguing that he is responsible for the negligence of his employee. Which of the following legal principles is the most relevant in determining Mason's liability for Clara's injuries? Is it the principle of contributory negligence? Clara must prove that she did not contribute to her own injuries to claim damages. Is it the principle of vicarious liability? Mason can be held liable for Jack's negligence if the act occurred in the course of Jack's employment. Is it 3, the principle of strict liability? Mason is automatically liable for any harm caused during construction projects. Is it 4, the principle of non-delegable duties? Mason is only liable if he personally caused the harm. Is it 5, the principle of occupier's liability? Mason's liability depends on whether Clara was lawfully present in the area. What do we think about this? Incidentally, I published yesterday a short video on vicarious liability. It's currently available initially to channel members. So, our channel members in here, you can go watch it. And I think it's got a really fun animation. So I'm investigating whether it would be nicer to make the videos as a talking head or with an animation or with a cartoon or stuff like that. So the ones that you prefer, give them the thumbs up so I know which ones you guys like, and then I can make some more like them. But yeah, I enjoyed making the video on the vicarious liability principle in tort and contract and sticking some animations in there. It was really good fun to do. All right, so what is our potential answer here? So I think we've got a couple of votes for option 2, which is vicarious liability. Yes, you guys are all correct. Congratulations. It is the principle of vicarious liability. It means that Jack clearly has been negligent because he left the equipment at the edge of the platform and it fell over and injured somebody. So that's definitely not cool. We're not saying that he did it on purpose, but we're just saying that he wasn't paying attention, which is precisely what negligence is all about. So, hey, we've got Devin there, one of our other channel members. How's it going? Thank you for joining us. So we've got Jack being negligent, but he's negligent in the context of his employment, right? And when that happens, then it is the employer that becomes responsible. So the doctrine of vicarious liability helps to transfer liability from the person who was physically directly involved to the people for whom they're acting. So it's a sort of principal-agent relationship, right? Jack's the agent, Mason's the principal. So the business that sent him there to carry out the work that he carried out badly will be responsible. Now, why do we have this in the law? Because we want the victims of whatever has gone wrong to be able to claim for adequate compensation. And most of the time, the random worker that did something wrong is not going to be able to compensate them adequately, most of the time because they don't really have the financial resources to do so. So we want the corporates that are in the background, that are ordering and controlling this work, to be responsible. So the real motivation, so Clara wants compensation for what happened to her. The clear motivation here is for her to sue somebody who's got deeper pockets than simply the worker who caused the thing directly. So vicarious liability gives us this pathway. It works both in contract and in tort, that when somebody carries out a negligent act in the course of their employment, then it is their employer that becomes liable for any compensation, not the worker by themselves. Now, the question was, which of the following legal principles is most relevant? Now, contributory negligence might be relevant, but it is not most relevant. So that's why you need to filter out what the question is actually asking in order to find the correct answer. In any sort of kind of tort scenario or any sort of kind of personal injury scenario, the potential for contributory negligence is there, which means that if somebody made things worse by themselves because they also did something wrong, so the victim did something wrong, the perpetrator of the thing did something wrong, so everybody's responsible to a degree. But this isn't what the question is about here. The question is, what is relevant in passing on this to Mason, and that is the doctrine of vicarious liability. If somehow Clara was negligent herself and contributed to her accident, for instance, she was working in an area that was cordoned off, that she wasn't supposed to be there, that might help to reduce the compensation that Mason has to pay. But Mason is still the person responsible, not Jack. Yeah. 3 was the principle of strict liability. No, this isn't relevant here. This is what we're talking about. And there is no strict liability in construction projects by default. Non-delegable duties, again, it's something that comes across, we come across in discussions about vicarious liability, but is not relevant to what's happening here. And the principle of occupier's liability, well, would have been relevant if Clara was in the building. She's not. But in any event, the question here isn't what is the source of the claim to begin with, which, part of the reason could be the responsibilities of occupiers. The question was, why Mason and not Jack? Yeah. So for that reason, even though, as I said, we've got multiple answers that are potentially relevant, the best answer that comes closer to what the question actually asks is number 2, the principle of vicarious liability. Alrighty, we sorted that one out, and yeah, you guys, our channel members can go watch right away the fun animation with the on vicarious liability, and it's gonna be available for the rest of you guys later on in the summer. Okay, now we have a hotel here, right? Lux Stay. Lux Stay Limited is a luxury vacation rental company. It contracts with property owners to manage and rent out, and they manage and rent out homes to high-end clients. As part of its agreement with property owners, Lux Stay includes a clause in the standard terms and conditions saying that they will not be liable for any damage caused to the property by renters. Sarah is a property owner who signed this agreement. She discovers that one of the renters, a client that was arranged by Lux Stay, caused extensive damage to her home during a stay. They smashed furniture, they ruined the carpets, they broke the windows. That must have been one hell of a party. Now, the repairs cost a total of £25,000. Sarah claims that Lux Stay failed to vet the renter properly and should therefore be liable for this damage. Sarah demands compensation. Lux Stay responds by saying that the exclusion clause in the agreement refutes any liability. Which of the following legal principles is most likely to determine the enforceability of the exclusion clause in this scenario, and what key factors will the court consider? Is the correct principle the Consumer Rights Act of 2015? The court will automatically void the exclusion clause as unfair as it limits liability for damage to the property. Is it the Unfair Contract Terms Act of 1977? The court will consider whether the exclusion clause is reasonable, taking into account a number of factors, including the bargaining power of the parties. Is it 3, the principle of vicarious liability that jumped over from the previous question? The court will assess whether Lux Stay can be held liable for the actions of the renters. Is it the principle of freedom of contract? The exclusion clause will be upheld because Sarah willingly signed the agreement. Or is it the principle of frustration? The court will determine whether the damage to the property made the contract impossible to fulfill. Aha. Okay, so what do we think? Are we thinking consumer rights? Are we thinking unfair contract terms, vicarious liability, freedom of contract, or frustration? Okay, let's see what we've got. We've got some votes. We're getting votes for number 2, the Unfair Contract Terms Act. Okay. In the agreement, there was a clause in the standard terms and conditions limiting liability. Okay. So it was saying that it was actually not only limiting, it was excluding liability. It was saying that Lux Stay will not be held responsible for any damage caused to the property by the renters. So you are suggesting that the correct answer here is number 2, the Unfair Contract Terms Act. Okay, quick question for you guys. Why is it not the Consumer Rights Act? Something that would help us say that the clause is unfair. So do we have any thoughts as to why the Consumer Rights Act is not the right one and we should go with this earlier legislation, the Unfair Contract Terms Act? I've got a suggestion. My suggestion is that this is not a consumer contract. Right? So this is one of these little definitional things that you need to be careful with. The Consumer Rights Act applies to contracts between suppliers and customers. Right? Here we've got people who are acting in the course of business. So Lux Stay is the vacation rental company. Sarah is it Sarah? Yes, Sarah is one of the owners of the properties. So their relationship is a business-to-business relationship. So we cannot use the Consumer Rights Act because it has no jurisdiction over this relationship. So before we even go in to consider what is it that he actually says and how the rules within the Consumer Rights Act work, one of the initial things that we need to do is to think what piece of legislation is the correct one, which one has jurisdiction over what's happening in this situation. And it cannot be the Consumer Rights Act because the argument here is between two businesses. So it will be, you're correct, it will be number 2. It will be the Unfair Contract Terms Act. And the Unfair Contract Terms Act applies to business relationships. And it does have mechanisms to allow us to judge whether an exclusion clause is appropriate or whether it goes too far. This is contained in Section 11 that talks about the requirement of reasonableness. And then, because admittedly, this requirement is expressed in such woolly language that, even if you read it 10 times over, you're not going to make any sense out of it. There is an appendix that gives you additional information on how to interpret the reasonableness test, which has to do with the balance of power between the parties, whether this type of clause is usual in the industry, whether the person received an incentive to agree to the clause, whether they could have gone to an additional provider, whether they had choices to do this deal with somebody else that did not include these terms and conditions. There are lots of things that are there within the Unfair Contract Terms Act to help us operationalize the reasonableness test. So in any event, without attempting to reach a solution, was this appropriate or not, we can say with a degree of confidence that the Unfair Contract Terms Act of 1977 is the correct statute, the correct thing to look at, and the assessment of whether the clause is reasonable or not is the one that the court will engage in. The rest are wrong. The principle of vicarious liability does not arise here. This is not an issue of vicarious liability. This is a matter of the balance of contractual risk and what has been put into the contract. Principle of freedom of contract? No, because we don't have endless freedom. There are some stuff that you're not allowed to put into your contracts because they're prohibited by law. There are some things that are considered automatically unfair or unreasonable and therefore are not applicable. So freedom of contract, yes, but this happens within certain frameworks. Now, principle of frustration, it is not irrelevant to the facts the way we've got them here. So we've got the first two possible answers that will kind of ring a bell to anybody who's been studying about exclusion clauses and all the rest of it. But the people who noticed that this is a business-to-business deal are going to be able to pick the correct one being number 2. Okay, now I'm going to show you, I've reached the end of the questions that I had, but I want to show you this again. Remember that we've negotiated a new discount code that you guys can try from Kinu Law. That is a newly launched application that gives you SQE1 style multiple choice questions, and then it gives you feedback on the results, and you can ask additional questions and all of that stuff. There's an AI bot that addresses your questions and offers additional feedback and resources and so on. It's a very interesting app that I recommend you give it a shot. You get 7 days free anyway, and if you use the promo code on the screen, you're going to get 50% off the normal price for 3 months if you wish to sign on as a regular customer. So guys, thank you so much for coming today. It's been great to have a lively chat. Thank you very much to our channel members for your continued support. It's awesome to see you here. So the people in the chat with the star next to them are the channel members. So it's been lovely. And while we're here talking, it actually got sunny outside. So if you guys are in London, then now to return to the stuff I was saying at the beginning about dealing with your mental state and your stress levels, I would recommend a walk in the park now that it's nice and sunny. Now, thank you so much for being here with me today. I'm going to see you guys again next Tuesday, same time, same place. And in the meantime, I'm going to send out the newsletter next Monday again. So thank you so much, guys. Have a great afternoon, and I'll see you again soon. Thank you. Bye.